Hello, welcome again. So, the first question is a very common one, and a lot of people have misinformation about this. I just got my PR and want to submit a super visa. Do I have to be a PR for 1 year? The answer to that question is no. You can submit a super visa as soon as you become a PR, and as long as you're meeting the LECO requirement and your parents can pass the medical, and you guys can provide 1 year of medical insurance that meets the IRCC requirement, you're good to go. You don't have to wait for 1 year. And this is a very common one too. So I'm a visitor in Canada. A lot of people had to go to a visitor, partly because of wrong information or out of necessity, and then they applied for PR because they got invitation either through express entry or got PNP and submitted a PR. Can they submit a BOWP? So this is a tricky one. The short answer to that is no, because you either have to be eligible for restoration. So if your visitor was granted within 90 days of you going out of status or the expiry of your work permit, then technically you might be eligible. But if you are a visitor in Canada and just looking for a BOWP, the short answer is no. You might be eligible for a T13 employer specific work permit, but even that is out of the question now because of the recent policy change, because visitors can no longer apply for employer specific work permits from inside Canada. So you might have to go to the border uh, to get your work permit. Or alternatively, you can just wait until your PR is finalized. What to do if I had a break in studies due to illness of family member? Okay, very common one. So especially for people who do a bachelor's program or program of study that are longer than 1 or 2 years. So these things do happen. So if that has happened, make sure you include the documentation and highlight your compliance with the conditions of your study permit. So if you took a break of 1 semester, that is legally allowed as per the study permit rules. And as long as you can highlight your compliance with the conditions of your study permit, the officer has to consider that when they make a decision on your PGWP. Okay. Next one is, what points does a close relative gives in MPNP, Manitoba Provincial Nominee Program? Okay, very interesting question. So people think if they have a close relative in Manitoba, then it gives them 50 point. Well, it does, but only if you're submitting a skilled worker outside Manitoba application. If you, because the relative points are sub points in the adaptability section. And if you are working in Manitoba, you get 500 points for having a job offer in Manitoba. So if you have a close relative in Manitoba and you're working in Manitoba, that close relative is only going to be one positive factor. So recently there was a draw where people were picked based on their EOI score, as well as the fact if they had a close relative in Manitoba. So it's a slightly tricky thing, but if you know what you're doing, it's pretty straightforward. So no additional points for people who have relative in Manitoba, but definitely a positive factor, which is often considered by MPNP when they make a draw. For instance, in 2024, I think there were 4 or 5 draws for people who had a close relative in Manitoba, with score as low as 615 earlier in the year. So this one, I'm applying for a visitor restoration and only paying 229 in government fees. Am I correct? So again, you're right. If the system is only asking you for 229, or the recent fees change that has happened, I think the fees for restoration changed to about 239 something. So you're right, because for a visitor, that is it's a temporary residence restoration, and for a visitor, that's the only fees that is required. So if you are thinking you also have to pay $100 fees on top of that, no, you don't. Just pay the 229, whatever the system is asking, and you're fine. MPNP work permit support letter policy update. Okay, let's talk about this one. So this was a policy announced earlier in conjunction with the Minister of Immigration 3 or 4 provinces participated in it. A lot of people are getting benefits, and I think it's a very, very well intended policy. It's going to happen a lot of people. So, but here's the thing: it's coming to end on Monday. So, if you think you are eligible or you want to try your luck in this policy, you have only until Monday to submit a work permit support letter request to the province of Manitoba. After that, there'll be no web form. They will not be accepting this. And another crucial thing is you have until December 31st to submit an application under this policy. For instance, if you submitted an application, let's say earlier in August, and it was refused, which has happened to some people due to mistakes, then you have until December 31st to submit a new work permit application with restoration of status fees. And as long as you include all the documentation, that application should get approved. And another thing about this policy was if you're outside the 90-day window of restoration, you can still apply and the officers may grant you exemption. It's not a shall grant you exemption, but they can definitely consider you for an approval, even if you're outside the 90-day restoration of status as a worker or a temporary resident holder. So now, one moment. Okay, let's talk about the study permit rules. There's another change. Now they're backtracking a little bit, possibly because of the pressure from the schools and whatnot. So let's talk about it here. What changes came in this week? Okay. So you can see here, starting November 8th, 2024, you must be enrolled, blah, 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 named on your study permit. That's the crucial one. Okay. Earlier, it used to be any post-secondary. Now they're going to name the college there. There you go. That's important. You must apply to extend your current one. So the important update this week was this one. Okay. If you were accepted to a new DLI for the winter or spring 2025. So spring, I think, starts around May. May intake is considered spring. Winter is January. You can start studying at your new DLI if here have been accepted. That's no brainer. But you still must apply for study permit extension as per this rule. Okay, asking you to change your DLI. Have a study permit that remains valid and doesn't have a DLI name printed on it. So this is when you submit your extension. Okay, very important. And you meet all your existing study permit conditions. So this is a tricky one. It's going to catch a lot of people off guard. So what are the study permit conditions in general? Let's talk about it. So the most obvious ones are what's listed at the bottom of your study permit. But the ones that really catch people off guard is number one, they have to tell IRCC if they have previously changed a DLI. If they have not done it, then they're in violation. Okay. Number two is if they were out of school for 150 days, even if the break was authorized, they must convert into a visitor. If they have not done so, I don't recommend starting studying, because that could be studying without proper authorization and could have consequences. I'm not saying it will, because I'm not the officer, but we're discussing here. We're basically doing the dirty laundry openly, and yeah, so it could have consequences later on. And if you have not studied for 150 days, that's the most common violation. The second violation is if you have even worked over 20 hours per week when you were not authorized. Okay, so this is the most tricky one of them all, and I highly recommend thinking critically before you try to take advantage of this policy. Because let's recall an IRCC policy that said they did a survey and found that approximately 70 to 80% of international students were non-compliant with the conditions of the study permit. So either somebody was not telling IRCC that they have changed the DLI, or they were working more than what they were authorized. So over 80% is coming from IRCC, not from me. So be very careful when you try to assess whether or not you meet the conditions of your study permit. So that's the study permit changes that came out this week. Again, this page looks like a mess. It's full of contradictions. If you try to read from the from top to bottom, you will probably end up with a lot of contradicting information on IRCC website. But that's just how it is. And this one, court case, inadmissible spouse. Okay, so very interesting case came out this week that highlights if your spouse or any family member is inadmissible, then the whole family becomes inadmissible for the purpose of a PR application, mostly. There are some cases in even work permit, study permit, and visitor visa where if one person is inadmissible, they make the whole family inadmissible. But the PR is the most obvious one, and the one that people really suffer if this happens. So let's look at the case here. So citizens of Pakistan who applied for skilled worker, medical doctor, bachelor's of medicine, that's totally fine. Yeah, permanent Canada in 2014. So it took about 10 years. 3 family members. There you go. Dr. Memon indicated her husband's profession as senior superintendent of police in Sindh Police in the Sindh province of Pakistan. Very interesting case. So you can see these were the things. Now that her husband, they brought him in for an interview and wanted to interview him on his activities while he was working for the police. And so I read this case beforehand. So this is the crux of it. Following the interview, inadmissible 351A, crimes against humanity, basically, because her husband was part of a police force that was involved in torturing the subject and using torture as one of the means. Okay, while he was not directly involved in the torture, the IRCC determined that he was complicit by working for the police force and by continuously working. So let's say once he became aware of the torture, he could have just quit or raised a protest or transferred to some other organization within country, but he did not do so. So you see, directly or indirectly in crime against humanity. So torture is very serious, and it makes people inadmissible, and rightfully so. Torture is not fun, and torturing people is not a good thing. So you can see here, by virtue of the husband being inadmissible, the whole family was found inadmissible based on paragraph 42(1)(a) of the IRPA. Very serious question. And I think there's some learning to do here for those of us who read court cases and try to learn from the mistakes of others. It is the inadmissibility of a spouse can definitely make the whole family inadmissible for the PR application. And it could be serious criminality, misrepresentation. For example, I read one court case a while ago where there was a international student in Canada who married somebody who was outside Canada. Okay, and they applied for PR. And it was during the course of the PR application that the girl found out that the guy had a previous 5-year ban. So that ban was still in effect. And by virtue of that ban, the girl also became inadmissible. So their PR application was refused. I'm not saying to do a background check if you're falling in love with somebody, but there are rare instances where these things happen. Okay. So there you go. Crime Against Humanity and War Crimes Act, and that made the whole family inadmissible. And the conclusion was the judicial review was dismissed here. By that, they mean that the decision stands, and the judge did not find any reviewable error in the decision, so they just dismissed the judicial review. One moment. So those are the things I wanted to talk about, and those were the questions that were submitted to us beforehand. However, there's certain other things I wanted to discuss. Number one is, a lot of people are confused what they should do if they have received a work permit support letter from any province. Okay, I'm going to pull up that policy so I can show you guys what to do. One moment. So, guys, let's say you applied for a work permit support letter, but your work permit was expiring, let's say, in September. Okay, and you got a work permit support letter in October or November. You're thinking whether I should submit a new application or should I send a web form on the existing application. So let's go to the effective date of the policy. Okay, because this policy only applies to the application that applies to received on or after coming into effect. So that came into effect on August 11. However, here's the another contradicting clause, that if there was another policy on June 26, 2024, if you submitted an application under that policy, they will be processed according to these rules outlined above. So if you have submitted an application, the conclusion is this: if you submitted an application after June 26, 2024, I recommend doing a web form and make sure you submit all the documents they have outlined in this policy. Okay, and refer to this policy in the footnote so the officer knows what you're asking for, because officers, they process hundreds of applications every day. You might expect them to know everything, but they're humans and they make mistakes. Okay, so make sure you cite this policy when submitting your application, and as long as you can get all the documents and explanation in front of them before a decision is made, you will be considered in this policy. Okay, so read this policy thoroughly. If your application was submitted before this date, submit a new application. If it was submitted after this date, because that's what this policy applies to, make sure you read this policy properly, include all these documents written right here with a letter of explanation, and make sure you provide a link to this policy to the officers so they know what you're asking for, because they process hundreds of applications on a daily basis, and you might expect them to know everything, but they're human, they don't know everything, and they do make a lot of mistakes. And we see those mistakes in judicial reviews and the settlements that lawyers get for clients. And another question that was submitted to us a little bit later through Instagram is, why are the visitor visas taking so long? Well, it's obvious that they're discouraging people from applying for visitors, and the refusal rate is quite high. And the other thing is, the processing time is 2 to 3 months, and 2 to 3 months is not that bad. That's what it used to take before COVID. And after that, they wanted a lot of people here. They used automation to grant visitor visas, but those things have changed. So we all have to adapt to situation, learn to be patient, just wait for updates from IRCC. If it takes longer than 4 months or 5 months, then try going through your MP. They might be able to like do something, talk to a program manager. But if it's less than 3 to 4 months, unless your situation is urgent, like family emergency, wedding, that's coming and IRCC has not issued a decision, then I recommend going to your MP and raising web forms. But other than that, just stay patient. 3 to 4 months is not that much time. That's what it used to take. But people, but during COVID, people got used to like really quick processing times, and things are going back to what they were. So that's it for today. If you have any questions, save them for next live stream on Wednesday. I'll hold one in the evening, and we'll also share a link where you can submit your questions directly. I look forward to seeing you on Wednesday. Stay safe and stay warm. It's pretty cold out there. Thank you.